Chair now recognizes the gentleman from Nebraska for 5 minutes.
Thank you, Mr. Chairman, particularly for coordinating this important hearing. Welcome to our witnesses. A number of years ago, in the wake of the near financial collapse due to Wall Street's reckless behavior, I had met with a group of Nebraskans who are members of the Chamber of Commerce. There were bankers there. And I looked at them and I said, how many of you used synthetic collateralized debt obligations? And they just stared at me. They didn't know what I was talking about. And I thanked them because our financial institutions back home didn't take advantage of liberalized credit, didn't do things out of the lanes, stayed responsible, lived up to their fiduciary responsibility. And so consequently, we have not suffered some of the problems that the rest of the country has because of this reckless behavior. The reason I say this is and I want to quote directly from a Wall Street Journal article that has just come out, and it's a new term I've never heard of called rehypothecation. And I'm going to quote directly from the article. MF Global's bankruptcy revelations concerning missing client money suggest that funds were not inadvertently misplaced or gobbled up in MF Global's dying hours, but were instead appropriated as a part of a mass Wall Street manipulation of brokerage rules that allowed for the wholesale acquisition and sale of client funds through rehypothecation. Would you explain this, please?
I really can't explain it. I don't think that's what our investigation has shown at this point necessarily. Now we're at an early stage, and it may be that we will find that there's money that went to account A, and then that it got rehypothecated somewhere else.
Let me read the next sentence. Okay. A loophole appears to have allowed MF Global and many others to use its own clients' funds to finance an enormous 6.2 Eurozone repo bet.
I think there was a repo on the securities side. I don't think at this point we know all the details of that or what the outcome was.
But again, the issue is the segregation of client accounts, and now we're learning there may be a loophole manipulated to get around this requirement. Am I reading this correctly?
Yeah, I think it's on the broker-dealer side, not necessarily the commodity side. It is something that we're looking into. It's a very complex transaction.
But it still applies because it's effectively commingling clients' funds, which is disallowed by these rules that we're talking extensively
Well, except I think it's on the broker-dealer side, not the commodity side. And one of the things we're looking at is in doing some of these transactions were commodities, funds that should have been segregated used were securities funds that should have been segregated used improperly. That's one of the things we're looking at.
How long do you think before we'll have that answer?
I just can't give you a definitive answer. As I said, we have this 60-day claim period. We'll know then what the amount of the claims are, and I'm hoping that in that time frame we'll have a pretty good idea of what happened at the broker.
I'm going to speed up some questions because the time's limited. Who owns MF Global?
Are you referring to the broker-dealer entity that we're involved in or the holding company entity?
MF Global. You define it.
Well, okay. The holding company, which was our parent company, is now in Chapter 11, and a trustee, an independent trustee, was recently appointed by the bankruptcy court. Our entity is...
So how is it structured and who owns it?
Well, it's now under the jurisdiction of the bankruptcy court.
Well, no, I understand that, but prior to this?
Prior to that, it was owned, I'm not exactly sure, but it was owned as any holding company would be. It had a management. It owned a number of companies, including our entity and a number of other affiliates.
Okay, it goes to the issue of fiduciary responsibility and to a question that the ranking member asked earlier. In regards to investigations, if you find that funds were inappropriately commingled, will you be able to go after the personal assets of people who violated the public trust here?
We would go after, we would have to look carefully at what the law says. If there's a theory, we would go after people.
Can particular personnel be held liable, accountable for personal funds?
I think it depends on the facts and circumstances. That certainly is something that we'd be prepared to do if the law provides for it.
Gentleman's time has expired.